Jaco's employer sent an email. It reads as follows. I've received various suspicious medical certificates from my staff. Must I accept the medical certificates as being true and accurate, or am I within my rights to verify the authenticity of the medical certificates? Where's the line drawn when it comes to the POPI Act and access to medical information under these circumstances?
All right. So where an employer suspects that medical certificates might be fraudulent, he's well within his right to confirm with the practice that whether the employer actually visited him and whether they actually issued the certificate to determine if there's fraud, if the certificate was altered, if it was bought, or whatever the case might be, or even if the practice is registered. It happens a lot of times that the registration number does not even exist. So the employer is well within his right to do that. What he cannot do is inquire as to the specific medical condition. That is privileged, but the rest is for lawful purpose, and in terms of POPI, that would be lawful and allowed.
If the employee gives the consent that the medical information be disclosed to the employer, the doctor is well within his rights to also then disclose that.
So yes, if the employee gives his consent that his medical information might be disclosed, then it is permissible for the doctor to do so. Without his consent, the medical practitioner will never do so.
And last question, is the employee forced to give this consent?
No, of course not. It's his own privileged information.